So thank you all for being here today. I am Brittany Fitzgerald, Workplace Experience Manager for BECO. Please join me in welcoming Todd Bornstein, an attorney with Selzer Gurvitch. Todd is going to fill us in on the benefits of a trust, types of trusts, and how they can protect our assets. I'm going to turn it over to Todd now so he can get us started.
Okay, Brittany, so before, if people are going to ask questions in chat,
yes.
So while I'm talking, we got it. So while I'm at the end of a slide, if somebody, just say, if somebody has a question, just let me know and I'll answer the question and then we'll move on.
Sure thing.
Okay, that work? All right, so hello everyone, and it's good to be back. I guess I spoke about maybe a month and a half ago, and on, I think I did, it was a little more expansive topics. I think I talked about powers of attorney and wills and potential problems with wills and irrevocable trusts. And I touched a little bit on revocable trusts, but I didn't really go into them a lot. And people said, oh, well, we want to find out more about that. So here I am. So today I'm going to focus on revocable trusts, irrevocable trusts, and I'm going to really explain how each is used, why would you use one over the other, and what the benefits are. Okay, so, and I'm going to start on revocable trusts first. So the main reason why people use a revocable trust is to avoid the probate process. Okay, and that's different than an irrevocable trust, which has a lot of other benefits. So an irrevocable trust, as I will discuss and get into later, helps with asset protection, creditor protection, divorce protection. It may save estate taxes. Okay, but a revocable trust doesn't do any of those things. But what it does do is it avoids the probate process. So why would you want to avoid the probate process and what is it? So I'm going to first explain that and then explain the probate process, why that is, and then I will show you how a revocable trust is used to avoid that process. Okay, so first, what is probate and why do people make such a big deal out of this? Oh, we got to avoid probate, it's the worst. So a probate is a court supervised proceeding that when somebody dies, okay, whether they have a will or they don't have a will, if they have assets in their name, so bank accounts, brokerage accounts, a home, if they have assets in their name solely when they die, you got to get it out of their name so it can go to the beneficiaries, their family members that are outlined in the will. And the only way to do that is through the probate process. So let me give you an example and let me explain it. Okay, so suppose my mother dies and she is survived by me and I'm an only child. And at the time of her death, she has two assets. She has a Bank of America account worth $1 million, and she has a life insurance policy worth $500,000. And her will, which I have the original will, says everything goes to me, and she appoints me as the personal representative of her estate, which means that's like the executor. So I have control over administering her estate. Okay. And so the question is, how do I get the money? Okay, because it's $1 million and I'd like to get my hands on it as soon as I can. And then there's life insurance, and that's $500,000, and I'd like that. So let's talk about the life insurance. For life insurance, what my mother did is there's a beneficiary designation form that she filled out and submitted with the life insurance company. And on there, she said that if she dies, she designated me as the primary beneficiary of the policy. So when she died, I called up the life insurance company and I said, I'm designated as the beneficiary. How do I get my money? And so the life insurance company will send me a claim form. It's a beneficiary claim form. And they mail it to me and I fill it out. I write my name and I fill in my address and I tell them where to send the check. I send it back and the life insurance company sends me the check for $500,000. It's mine and I can deposit it into my account. So in that case, I don't have to go to a third party or get the courts involved or anything. I just have to call up and deal with the life insurance company. I notify them, my mom's dead. I send them the death certificate to prove she's dead, and they send me the money. It's easy. Okay. What about the bank account? How do I get the $1 million? Okay, so what happens is I go down to Bank of America and I bring the will and I bring the death certificate and I tell the teller at Bank of America that my mother died. I know she has $1 million in the account. And I show them in the will, I say, look, here, it appoints me as the personal representative. And I show them in the will that I am the sole beneficiary. And I ask the bank, I say to the teller, please write me a check. So I want to deposit, take the money out, withdraw the money, make a check out to me for $1 million. And the teller says, I can't do that because I'm not on the account. My mom is the only person on the bank account. So, with your bank accounts, you're the only one that can access them. Your friends can't. I can't go to somebody else's account and get the money. And same with my mom. I don't have the legal authority to withdraw money from my mother's account. Okay. So how do I get it? What I do is I file the will and I file the death certificate with the probate court. Okay, and that's in the county that my mother lives in, Montgomery County, Maryland. And that's the probate process. So what I do is I file the will, I file the death certificate, and I list all of the accounts and all of the assets that my mother owns. So I will write Bank of America, and I'll put in the value of $1 million. And if she had other assets, I would list those in. Okay. The court, the person at the probate court looks at it, they look at the will and they see that it was legal, it was properly signed and witnessed, and they look at the death certificate and it has a raised seal and it appears to be valid. And then what they do is they say, all right, it looks like Sheila Bornstein, my mother, died. This is a valid death certificate. This is a valid will. And it names Todd as the personal representative. And then what they do is they send me a document called a letters of administration. And it's a one-page document with a raised seal from the probate court. And it appoints me as the personal representative of my mother's estate. Okay. Now that I have that document, that allows me to step into my mother's shoes, and I have legal authority and legal access over anything that my mother had. I now have that same legal authority. So I take that letters of administration back down to Bank of America. I give them that, and now I can get to the money and I can withdraw the money. That is the probate process. It's a way that I can file the will, file the death certificate, and get officially appointed as the personal representative. And that allows me to take control over my mother's assets and then distribute them according to the provisions of the will. Okay. What else is involved in the probate process? So one, I talked about, I can get access to the assets, and I have to distribute them according to the terms of the will. Well, in this case, I'm an only child, but suppose I had siblings and my mom named me the personal representative, and she said everything gets divided in equal shares for me and my siblings. Well, then I'd have to distribute everything according to the will. Okay. What else do I have to do? Well, if my mom dies, let's say she dies, let's say she died today, January, whatever the day is, 2026. Well, I'd have to file a final income tax return for her for 2021. for the 1 month that she lived in 2021, I have to file an income tax return for her due next year to report that income. So one of the other roles or duties of a personal representative is to wind up the affairs of the person who died. So it's paying their last income tax return, also bills. So I have to pay, let's say my mother had outstanding medical bills or credit card bills. Those have to be paid. And so I, as the personal representative, can use the money that my mother had, that $1 million in the bank account. I use that first to pay her taxes, to pay whatever bills she had, and then whatever is left, I then can distribute to me as the sole beneficiary. Okay, and then the last part of the probate process is I have to file an accounting with the probate court. So, and what is that? So the first thing on the account, it lists all the assets that my mother had at the time of her death. So in this case, it's only that Bank of America account. So I list that on top of, Bank of America, $1 million. And then I list all of the expenses that came out of that. So I might list the credit card bills that were paid. I'll list the medical bills that were paid. I'll list the probate fees that were paid. So let's say the total amount of all those expenses and fees were $50,000. So I'll show that, and then I'll show that there's $950,000 left. And then I show, and I write down distribution to Todd, sole beneficiary of the 950, and then that closes the account because I've now accounted for all of the money. Okay, that is the probate process. Okay, so why do people not like that process? Okay, the biggest thing that I hear is lack of privacy. So in this case, I have to list all of the assets that my mother had in her name. So in this case, it was a Bank of America account of $1 million. Well, I got to write that down, and it's a public document filed with the court, and people can access that. So if people don't want anyone to know their business or what their family members had when they died or what they're going to inherit, you don't want to have to list all those with the probate court. And you need to, if you have assets in your name and you have to, and the only way to access them is to go through the probate process, then there's really no way of getting around that. You have to list all the assets and their values. Okay. The second reason is it's possible that there could be a delay. Now, normally, it's not too hard to open up a probate estate. So in Montgomery County or in most places, I can file the will and file, it's called the petition of probate. That may take a week or two and you can open up the estate. Now, when COVID happened, the courts were closed for a period of months. So in that unique situation, you couldn't get access to the money or to pay bills or anything for a few months. But again, that was a unique situation. But normally, the delay of the assets is not that big of a deal. And then finally, people say, well, probate, there are increased costs. You may have to hire an attorney, or you have to maybe appraise assets. So in my mother's case, since she rents a home, she didn't have to, put down a value of a home and the value. But if she owned a home, then when I listed and I submitted the inventory and the accounting, I'd have to list the home, and I'd also have to list the appraised value of it. And so I might have to hire an appraiser to get the value. So those are some expenses associated with the probate process. Okay, I talked a lot. Any questions?
We don't seem to have any yet.
Okay, all right. Well, that's a good thing. Okay, so how can you avoid the probate process? Well, one is by way of a revocable living trust, and I will talk about that in a minute, but I'll talk about a few other ways. So one way, which is number 2 on here, is the life insurance policy, for example, That didn't have to go through the probate process. All I did was fill out a claim form. I sent it to the life insurance company, and then they sent me a check. I didn't need approval from the Register of Wills or the probate court. So assets or accounts that have beneficiary designation forms, such as life insurance or 401ks or IRAs, they don't go through the probate process. Whoever is designated as the beneficiary, and usually there's a primary beneficiary and a contingent beneficiary that you fill out on your like 401k or your life insurance. The beneficiary just files a claim with the life insurance company or the custodian of the retirement account, and then they can get their money. Okay. Another way is accounts called payable on death, POD accounts, or TOD, transfer on death accounts. So like in the example in my mother's case, where she has $1 million at Bank of America, some banks allow that to designate a beneficiary on a non-retirement account, such as a normal checking account or even brokerage accounts, the brokerage accounts that have stocks and bonds. So my mother could have just written as the payable on death beneficiary, me. And if that was the case, then again, I wouldn't have had to go through the probate court. Okay, so more and more you are seeing that banks and brokerage houses will allow these POD or TOD accounts, and that is a good way to avoid the probate process. Okay, another way is if my mother's account had a joint owner. So accounts that have more than one person on the title, they don't go through probate. They just automatically pass to the surviving owner. So for example, suppose my mother had me as a joint owner of the checking account. Well, if she died, then on her death, I automatically would become the owner. So that is good for avoiding probate purposes. So I just go to the bank and I say, look, my mom's on the account and I'm on the account. I have legal access. I can withdraw the money. Okay. The potential problem with that is that if I have creditor issues, let's say I get sued, I'm in a car accident and I get sued, or I get sued in a business deal or whatever may happen. Since my name is on my mother's account, it's possible that one of my creditors could get to that money. And that is not a good thing because it's really not my money, it's my mom's. She just thought she'd add my name to the account to avoid the probate process. I see that a lot. That's not a good idea. Okay, what would be better is not to make me a joint owner, but instead to make me, as I talked about, a POD beneficiary so that I'm designated as the beneficiary at the time of her death. Okay, that being said, accounts for husbands and wives that are jointly titled, that is a good thing because bank accounts, homes, other assets that are jointly titled between a husband and wife offer increased creditor protection. So that is a good way to hold assets and as well will avoid probate. Is there a question?
Yes.
Okay.
How is life insurance handled when the beneficiary is deceased?
Yeah, so that's a good question. So usually on the beneficiary form, there'll be a place where you can write a primary beneficiary, and then you can write a contingent beneficiary. So you'll look to the form. If there's a primary and that person's dead and the owner of the life insurance failed to designate a contingent, then usually it gets paid to the estate. And in that case, that the life insurance proceeds is a probate asset, and you would have to report that as being part of the probate estate. Okay. All right. The third way of avoiding the probate process is by using a revocable living trust. And so I will explain that. All right. Again, a revocable trust, really the sole purpose is avoiding the probate process. And this is what a revocable living trust is. Okay. A trust is created by an agreement, and it's a written document. So it's just like a will that you've seen that may be a bunch of pages. A trust agreement, is written out, and it describes what happens to the property, and it sets forth what the terms are that governs the trust. Okay.
Hey, Todd, before you move forward, we do have a question.
Yeah.
Is there a difference between being added to an account as an authorized user versus just as an account holder?
Yeah, so that's a very good question. Okay. So there are different ways that you can add somebody's name to an account. So for example, let's say you have an elderly parent, and the parent wants one of their children. We see this all the time. They want one of the children, one of the adult children, to be able to pay bills on behalf of the parent and have access to the account, but they don't want them to be a joint owner. Okay, and that is essentially an authorized person on the account. Now that is not, that may be a good thing. So you're allowing somebody, it's sort of like a durable power of attorney. Mom is allowing somebody that she trusts, one of the children that she trusts, to access the account and to pay bills from the account on behalf for the mother, because the mother can't do that, but it is not the child's money. And so that would be different than if the child was on the account as a co-owner. And so that would be what's known as an authorized payee. Okay. All right. So back to the revocable trust. So here's what happens. I create a trust for my benefit. So every trust, there are three parties. There's the person that creates it, there's the person who is the beneficiary, and there's the person who's the trustee that manages the trust money. So for revocable trusts, it's the same person wears all three hats. So if I create a revocable trust, I put in my money to the revocable trust. I am the beneficiary, meaning the money in that trust can only be spent on me, and I'm the trustee. The trustee is the person that has legal authority on the assets in the trust. My phone just went off. Okay, so here's what happens with a revocable trust. I create the Todd Bornstein Revocable Trust, and I put in my Bank of America account and my brokerage account at, let's say, Charles Schwab. And so I title it on the checking account. Instead of it saying Todd Bornstein, it'll say on the checking account, the Todd Bornstein Revocable Trust. For all purposes, I can use that money for myself just as I do now. So I can write checks out of it. I can make withdrawal and deposits. It's my money really for all purposes. Same with the brokerage account. Instead of the statements coming to me saying Todd Bornstein, it'll say Todd Bornstein Revocable Trust. But the statement will show the stocks and bonds, but it will look just the same as it did before, but it will just have revocable trust at the end. Okay, so the first part of the revocable trust says, while I'm living, whatever assets I have titled to the revocable trust, I can use like for myself, just as I always did. Okay. The second part of the revocable trust, so this is paragraph number 2, says that when I die, whatever is in my revocable trust gets disposed of pursuant to the terms. It's exactly like a will. So, for example, in my revocable trust, I'll say, while I'm living, the money is used for me and it can go to me and I can use it however I want. And then it says, when I die, whatever's left goes to my wife. And if my wife predeceases me, it goes to my children. So it's the exact same terms that you would normally see in a will Instead, they are in this revocable trust document. Okay, so how does it avoid the probate process? So let's go back to the example of my mom. My mom dies. Again, I'm the only child. This time, instead of having the bank account, Bank of America, in her name, she has it in the name of the Sheila Bornstein Revocable Trust. So she set up this revocable trust. She changed the title of her Bank of America account to the Revocable Trust, and now it's titled in the name of the Revocable Trust. Okay. In the Revocable Trust document, it says that my mom is the trustee, so she had legal control over it while she was living. It was her money. Okay. Then it says that upon my mom's death, I become the trustee. Okay. That means that when she dies, I'm the trustee. I have legal authority over all of the trust assets. So what I do is I bring the trust agreement and my mother's death certificate down to Bank of America, and I show them that she's dead by the death certificate. And then I show them the revocable trust agreement. And I say, see here, my mom was the trustee. And it says here that I'm the backup trustee. And then that gives me legal authority over the money. And now I, as the successor trustee, can withdraw the money. I don't need permission from the probate court. The authority I have comes from the revocable trust agreement. Okay, that's how a revocable trust avoids the probate process. You title your assets into the trust while you're living. You use them for yourself, just like they were your own assets. But when you die, all of the provisions that would normally be contained in a will are instead in the revocable trust, and then they go to the beneficiaries that way. And so it's by virtue of naming a successor trustee of the trust that allows you to avoid the probate process.
Okay. Hey, Todd, just quick question for you.
Yeah.
Is a revocable trust a good idea for married couples as well?
Yes, so it's definitely a good idea. So like I said, most married couples, they will have their assets jointly titled. So they'll have their home will be jointly titled, and their bank accounts and brokerage accounts, all of those things will be jointly titled. And I told you that if they're jointly titled, there is no probate. So let's say everything's jointly titled and husband dies first. Well, we know that at that time, everything's going to go to the wife, and there is no probate. So it didn't matter whether a husband had a will or a revocable trust or anything. It wouldn't have mattered if husband had a revocable trust, because nothing was titled in the trust. Everything was joint. Okay, but now wife is living. She now has all the assets in wife's name that were previously joint. So what wife then does is she then transfers the assets to her revocable trust, so that upon wife's death, when the assets are going to go to the kids, they will avoid the probate process. So usually, so then you might say, all right, well, you don't need a revocable trust until the one of them dies and it's the survivor. Well, because you don't know who's going to be the survivor of a husband and wife, and because they're going to have to do a will anyways, usually for most of my clients, we set their documents up as revocable trusts. And so it may be that they remain unfunded because most of their assets are joint. But then when one of them dies, then I will work with the survivor and will fund the trust so that at the survivor's death, everything can pass to the kids without going through the probate process. So the answer is yes, most of my clients still use revocable trusts, husband and wife, even if many of their assets are currently titled jointly. Were there any other questions?
Could you theoretically just keep your mom or parents' assets in the revocable trust account you took over, or do you pull the money out and open your own
Yeah, so,
Revocable Trust.
right, so when my mother, so in that example, my mother dies, so she's got $1 million in there, and the trust document says it gets paid to me. You can't really keep it open. It's a, at some point and it's a reasonable amount of time, you close it because it is my property, it's legally my property, and I have to pay. Well, once she dies and there's the $1 million in there, if I, for example, if I had creditors, or they could access that money even if it still remained in that trust because I'm entitled to it. So there really wouldn't be a reason to keep it open in that trust because I'm the beneficiary. I want to use it. So it has to go. You would close that trust, my mother's revocable trust, and distribute it out to me. Okay. But in a minute, I'm going to talk about that, a way that instead of the money coming outright to me, my mom could have left it in a separate trust for me. Okay, not a revocable trust, an irrevocable trust for me that will offer other benefits. So I would close my mother's revocable trust and then transfer the assets to me in an irrevocable trust that offers a lot of benefits. And that's what I'm going to talk about right now. All right, but before I do, I want to go back to the revocable trust. So I have the Todd Bornstein Revocable Trust, and I have my brokerage account in there, and I have my checking accounts in there. And at the end of the year, I get a Form 1099 from my bank account. It says, all right, I earned $1,000 of interest on my money on the checking account. But it's not in my name. It says the 1099, the tax form says that it's the Todd Bornstein Revocable Trust that earned $1,000 of interest. And I get a 1099 from Charles Schwab, and it says that the Todd Bornstein Revocable Trust had $10,000 of capital gains and various dividend and interest income. Well, what I do is I report that income that says it's to the Todd Bornstein Revocable Trust. I report it on my income tax return. I don't have to have a separate income tax return for my revocable trust, because for all intents and purposes and for income tax purposes, the revocable trust assets are my assets. Okay, so I just report those on my income tax return. All right. Also, if I were to get into a car accident and I have my brokerage account and my bank account in the name of the Todd Bornstein Revocable Trust, and I'm sued, I can't say, well, it's not my money, it's in the Todd Bornstein Revocable Trust. No, it's my money, and my creditors can get to my revocable trust assets no differently than they could get to my assets. The revocable trust is my alter ego. It is me for all purposes except the probate process. I don't have to go through the probate process. But other than that, whatever's in my revocable trust, it is mine while I'm living for all purposes. All right, were there any other questions?
Yes. So
Okay.
Revocable trust, does that allow for a primary trustee, secondary trustee, et cetera?
Yeah, absolutely. So most of my documents have that. So like for mine, it'll say the top that while I'm living, I am the trustee of my revocable trust. So that means if I title my Schwab account in the name of my trust, I have control. So I can call up Schwab and I can make trades, buy, sell, etc. If I have my checking account, I can access it, the checking account. Well, let's say I am now 80 years old and I become incapacitated. I can no longer handle my financial affairs. I have Alzheimer's. Well, I'll name my wife or my son as the successor trustee, and then they can go in and access, while I'm living, they can go in and as the successor trustee, they can access all of the assets in my revocable trust by virtue of them being a successor trustee. So almost all of our documents, people will name successors in the trust agreement. And let's say I name me as the primary, and then I name my wife as the successor trustee. There's provisions in there that if I can't serve and then my wife can't serve, she will have the ability to appoint a successor or co-trustees to work with her. So all trust agreements have provisions to appoint successor trustees, co-trustees, and sometimes to remove and replace trustees. Anything else?
Perfect.
Okay. Yeah.
Yes, other son example. Does the revocable trust dissolve after the mother's death?
It does. So what happens is, the revocable trust was again, for income tax purposes and for all purposes, was my mother during her lifetime. So let's say, for example, my mother dies in, let's say July 1st of last year, 2020, July 1st, she died. So for the period from January 1st, 2020 to July 1st, 2020, whatever income and dividends and interest associated with the accounts, the bank accounts titled in the name of her revocable trust, will be reported on her personal income tax return, her final return for 2020. Okay, but when she died on July 1st, the revocable trust used her social security number on all of the accounts. But when she died, that revocable trust terminated and it became what we call an administrative trust. And it's at that time that it's actually an irrevocable trust, which I'll talk about in a minute, but it terminates. And then from that period of time until we distribute the assets out to the beneficiaries, it's sort of this administrative irrevocable trust.
Perfect.
Okay.
Do you need your child's permission to add them to a revocable trust?
No, so my clients, they come in and they'll, like husband and wife, they'll add each other as the trustees. And then they usually will put down, let's say they have responsible adult children, they'll name them. But the people that are designated as successor trustees don't need to sign the document. So originally, when I create the trust, the creator, the grantor, has to sign and the trustee has to sign. But in a revocable trust, they're the same people. So when I set up my revocable trust, I sign as grantor, the creator, and I sign as trustee. So the original trustee has to sign it, but you don't have to have successor people sign it. Okay, but let's say I name my adult child as the successor trustee, and I name them to serve when I can't serve. Just because their name doesn't mean they have to serve. So they don't have to serve. If they don't want to take over that role, then they just say, I'm not serving. And then you look to the document, you go to the next named successor, or if there isn't, there usually are other mechanisms to appoint a trustee so that there's always somebody that has that's a trustee that has legal authority over the trust.
Perfect. And I think we have two more questions before we move on.
Good.
What are the costs involved in probate, and can someone in the family contest the probate?
Oh, so the probate costs, it depends. So the fees involved are usual. The fees that you have to pay the probate court, less than $1,000. It depends. It's based on the size of the estate. But I'd say in the low, hundreds to thousands of dollars, but not tens of thousands of dollars. Okay. So maybe, the fees are not that great. What could be expensive is if you have to file an inventory with the probate court or prepare an accounting with the probate court, that could become a little expensive. So you may have to pay attorney's fees or appraisals fees. So, it depends. Like a commercial property could be a few $1,000s to appraise a commercial property if the decedent owned that. So it depends. Oh, so then the second question, can somebody contest it? Yeah, when you file a will, somebody can contest the will. They could say that, let's say my mother's case, I file her will, and let's say I had a bunch of siblings. My mother could say, one of my siblings could challenge it and say, she wasn't competent. She wasn't mentally competent when she signed the will and left everything to me. Or so, yeah, you can challenge the will based on duress or the person didn't have mental capacity. Okay, but also you can also challenge the legality of a revocable trust. So let's say that instead of a will, my mother signed a revocable trust and I had siblings. And again, my mother in her revocable trust left everything to me and didn't leave anything to my siblings. That could be challenged. It's generally harder to contest a revocable trust than it is a will, but both of them can be challenged if there are grounds. How am I doing on time? What time? 1:40.
Yeah, it's a 1:43, so we have about 15 more minutes.
Okay, good. All right. So this time I spent a lot of time, because I don't think I really spent much time on revocable trusts. So now you understand those. Revocable trusts help avoid the probate process. They don't offer creditor protection. They don't save estate taxes. They don't offer divorce protection or any of that. They're a way to own your property while you are living, to then pass your assets to your family members without going through the probate process. That's what revocable trusts do. Okay. Now I'm going to talk about irrevocable trusts, which are totally different, that are not used to avoid probate, but they are used to a way to hold title to assets that can offer creditor protection and divorce protection, and in some cases save estate taxes if they would otherwise apply. Okay, I used this example last time. I think it's a really good example, and I'm going to go over it again. Okay, so in this example, you have Dad, Joe Smith, who died 10 years ago, and he left all his assets to Mom, Sally Smith. Okay, Mom died, and she had assets in her revocable trust. She owned a home and a bank and a brokerage account, and she left, and they were worth $1 million. And she left all of that. While she was living, titled the home and titled the brokerage account in her revocable trust, and she had a life insurance policy, and she designated her revocable trust as the beneficiary, so it avoided probate. And so upon her death, the revocable trust had $1 million. Okay, so there was no probate. And her revocable trust leaves all of the assets equally to the two sons. There's Adam and there's Brian. They're each getting assets worth $500,000. Okay. Adam's share, she just leaves outright to Adam. So the successor trustee of the revocable trust, after they paid all the expenses and dealt with and wound up mother's affairs, the trustee writes a check to Adam for $500,000 and he deposits it into his bank account. Okay, Brian's $500,000, on the other hand, doesn't go to Brian in his individual name. Instead, it goes to the Brian Smith Trust, which is an irrevocable trust. Okay. In this case, remember I said there are 3 parties to a trust. So in a revocable, back to the revocable trust, I used my money. I was the grantor. It was my money. I put it into a trust for my benefit, because while I'm living, I'm the beneficiary of my revocable trust. Okay, so I'm the creator. It's my money. I'm the beneficiary. The money's used for me. And I was also the trustee. I have control over the accounts in my revocable trust while I'm living. Okay, I'm all 3. Okay, in this case, it's different. This was Mom's money. She was the grantor, the creator of the trust, and she's giving it to a trust for the benefit of her son, Brian. So Mom's the grantor, Brian is the beneficiary. And in this case, the trustee is me, the lawyer. Mom didn't want Brian to be able to use the money as Brian wanted. Brian has creditor issues and Brian's a spendthrift. And mom thought that if she died and she left the money to Brian, he'd blow it all. So instead, she created a trust that I manage, and I will dole out money to Brian as he needs it, but I'm the trustee and I have control over how the assets are managed and how they're distributed to Brian. Okay, so this just again talks about the operations of the trust. So again, I'm the trustee and I take the $500,000 and I invest it in a Schwab brokerage account and I invest it in stocks and bonds. And the trust provisions say that me as trustee, I can use the money for Brian. I can use the money for Brian's children or grandchildren. If they need money for whatever it is, I have the ability to write checks and make distributions to them. And then the trust agreement says that upon Brian's death, whatever money's left, I will distribute equally to Brian's kids. Okay, those are my marching orders as the trustee, and those provisions are written in the trust agreement, and I have to follow them. Okay, so I talked about this. I open up an account at Schwab. Okay, unlike a revocable trust, this irrevocable trust has its own tax ID number. It's its own separate legal entity and its own separate tax-paying entity. So every year, so let's say at the beginning of the year, it had $500,000 of stocks and bonds. And at the end of the year, it had $10,000 worth of interest and dividends associated with that account. The trust, as a separate tax-paying entity, has to file an income tax return. So, and that return is due April 15th. So I, as the trustee, will hire an accountant. They'll prepare an income tax return for Brian's trust, and the trust will have to file the return and pay the income tax associated with whatever income was earned. Okay, Brian, it's not his money. Brian, if no distributions were made to Brian, Brian doesn't have to pay the income tax. If all of the income stayed in the trust, then I, as the trustee, will use the trust money to pay the income tax that Brian's trust earned during that year. Okay. All right. As the trustee, what are my duties? So here I am. I have $500,000 in a brokerage account, and my job is to preserve the money and use it for Brian and his descendants, Brian and Brian's children. Well, one, I have to invest it, we call prudently. I have to, I'll hire an investment manager that will help me invest because I'm a lawyer, not a financial advisor. But what I can't do is say, take the money, take Brian's trust money and go to Vegas and bet it all on black. If I do that, I would be breaching my trustee fiduciary duty. So as the trustee, I have to manage it in a prudent way for Brian's benefit. Okay. The other thing is, I have to let Brian know what's in the trust. I have to give Brian statements, brokerage statements, or an accounting, and there has to be full transparency. So as a trustee, if I'm entitled to a fee, I have to let Brian know what my fee is, what I paid myself that year. So, and I have to let Brian know what the accounting fees were and what the income tax was. Full transparency. Brian is entitled to full transparency of everything that I do as the trustee, because if I didn't disclose that information to him, he'd have no way of knowing whether I was stealing money from the trust or anything. So I have to give him all the information so that he knows that I, as the trustee, am fulfilling my duties, managing the money properly, and for him, and preserving the money for him. Okay, let's go on. So in my example, mom died. There was $500,000 went outright to Brian, and $500,000 went to me. $500,000 went outright to Adam. He deposited that into his account, and the other $500,000 went to a trust for Brian, and I invested it into account. 10 years pass, and now both accounts have $800,000 in them. Okay, well, COVID hit. This was at the beginning of last year. There was 800,000 in each, and COVID hit, and Adam and Brian were both stuck in their homes, and they and their wives did not get along after being cooped up in their home together during the months of COVID. So they both ended up getting divorced. And as a result, half of Adam's property, because when Adam received his money 5 years or whatever, 10 years ago, he commingled it with money that he earned while he was married. And half of that account is deemed to be marital property. And when he got divorced, he had to pay his wife half. So Adam is now left with $400,000. On the other hand, the money that went to Brian's trust, it was not in Brian's name. It was in a trust, which was a separate legal entity. And that account never became marital property. And when Brian got divorced, that whole trust was preserved. So at the end of the year, after both got divorced, Adam had half of his money and Brian still had all of it. Okay, another 5 years goes by, and now Adam's account has gone up a little bit to 700,000, and I've done a pretty good job managing Brian's trust, and it's now $1,100,000. Well, they had another bad year. Adam was a real estate developer, and a deal went bad and he got sued. And the judgment in excess of whatever insurance he had was for $800,000. And the bottom line is, since all that money was in his name alone, it was in his individual name, and it was in excess of whatever insurance he had, and the judgment was more than what the account was, he lost it all. Brian was in a bad car accident that year, and he got sued for $2 million in excess of whatever his coverage was. The entire trust is protected. None of the trust assets were needed to pay the creditor, or in this case, the plaintiff of the lawsuit, because it was not Brian's money. Instead, it was in a trust for Brian. Okay. Almost all of the wills and revocable trusts that I prepare, almost all of them, we don't leave money outright to the children. Instead, we leave it in a trust for the children, because if it's in and this includes adult children as well, because if it's in the trust and it's in that trust wrapper, it's protected from, again, creditors or divorce. Now, in the example I used, I was the trustee for Brian's trust. So Brian had to come to me every time he needed money. But we could also structure it, and I do this for many clients, that Brian could be the trustee of his own trust. He doesn't have to come to me. Brian would be the trustee. He could manage it and make distributions to himself. So he'd be the trustee and the beneficiary. And he'd still get all of those protections that we talked about, even if he was the trustee. So almost, again, almost universally, that's how we structure our clients' estate planning documents. We leave the assets in irrevocable trusts when people die, so that it offers those protections. Okay, so to wrap things up, we went over what a revocable trust does, which avoids the probate process, doesn't offer creditor protection, doesn't save estate taxes, no divorce protection, in contrast to an irrevocable trust. That is a way that when you give money to somebody or bequeath money to somebody at your death, it's a way to give them money so that it is protected. And that is a wrap. That is it. Are there any questions?
We do have
a
few questions.
Okay.
Hold on 1 second. Let me pull it up. Referencing back to life insurance having only beneficiary who is deceased,
Yes.
it has been closed. Later, the conservator of the estate was notified by the insurance company that this life insurance existed.
Right.
Handled.
You open up the estate again. So the whoever the personal representative will just reopen up the estate for purposes of because what will happen is if there's no, let's say the primary beneficiary dies, and the life insurance contract says that if there is no successor, the beneficiary is the estate, which means that the check that the life insurance company writes, and they don't have a choice, the check is going to say the estate of John Doe, okay, whatever the name is. And so let's say they write that check, estate of John Doe, because that's the only beneficiary that the life insurance company, they can't write it to anything else. If the primary beneficiary is dead, they must make the check payable to the decedent's estate, so the estate of John Doe. So you have this check. Well, remember, the sole purpose of the probate process is to be able to cash checks or get access to assets if you don't otherwise have the ability to do it. So if you have a check payable to an estate, there is no one or no legal way to cash that check other than to have somebody appointed as the personal representative of the estate so they have legal authority to cash it. And if the estate was closed, then you just reopen it. And by the way, that happens. So sometimes an estate will be closed, and then maybe a year later, you'll find, there may be unclaimed property with the state. You'll receive notice. Well, in order to get that, or to get undiscovered assets, you have to open up the estate again so that you can then gain control and then distribute them out.
Perfect. In this customer's will, a trust was set up for her minor daughter with another family member as trustee until she reached the age of 27.
Right.
She's now 27. Does the customer need to change the will to make her or an attorney as trustee?
So there was a will that mom set up, and it left money to daughter or whoever it was till they're 27. And so if the provisions of the trust say that at 27, the trust terminates and it has to be distributed to daughter, then that's what happens. I mean, you have to follow the provisions of the trust agreement. And so if the will says at age 27, it's to be distributed, then that's the end of it. The trust will terminate and the assets will be distributed out.
All right, I think we have time for just a few more questions.
Okay.
Can you set up an irrevocable trust for your own assets, or is it only for people transferring assets to other people?
Okay, so that's a great question. So wouldn't it be great if I could just take all my assets, okay, and put them in a trust so that and say, oh, if I'm sued or I'm in a car accident or that I can say, oh, it's not mine, it's in this trust, it's in this irrevocable trust, and so, you can't get to them. Well, in Maryland and in most states, they don't recognize those types of trusts. So in any type of trust that I take my money and I put it in a trust which I can still benefit from, whether it's revocable or irrevocable, as long as it's my money and I can still access it, those don't work. Now, there are some states like Alaska or Delaware where they do have those types of trusts, asset protection trusts, where if you are in those states and you hire a Delaware trustee, so a corporate trustee that is in Delaware, and you're a Delaware resident and you put it in a trust and it has the requirements, then you may be allowed to do that. But in Maryland and DC and in Virginia and in a lot of states, they're not recognized.
Perfect. Is the irrevocable trust protected from Medicaid?
Well, so it depends how it's written, but generally, if it is structured properly, the answer is yes. And that's a reason why a lot of people structure irrevocable, why they might leave money in an irrevocable trust for the benefit of others or even husbands and wives, and they structure it specifically for Medicaid purposes. So absolutely. Yes.
All right, and then one last question.
Okay.
So this customer stated, so an irrevocable trust also avoids probate, correct?
Well, it does. Yeah, it does, because let's say my my mother had $1 million. Okay. And while she is living, she wants to make a gift to me while she's living, not while she's dead, but she wants to make a gift to me. So she creates an irrevocable trust, and she puts in $50,000 or $100,000 in that trust. So when my mother dies, it's no longer hers. Right? That's one example. Let's go back to Adam and Brian. So there was, remember Brian's money when mom died, Brian's money went into an irrevocable trust for Brian. So when Brian dies, that trust, Brian's trust, not only did it would offer creditor protection and divorce protection, but Brian's trust does not go through probate. Where does it go? The trust agreement provides where it goes on Brian's death. And so the provisions are in the trust agreement. And so it probably says that when Brian dies, it goes to Brian's children. Well, the trustee of Brian's trust, me, I already have legal authority over the account. I'm the trustee of the account. I have access to it, and I can write checks to Brian's children. I don't have to go to the probate court or anyone else to get legal authority. I already have it.
All right, I think that does it.
Okay.
Thank you, Todd, for your
All
time
right. Well,
today.
thank you for inviting me.
Great. Absolutely.
I know we went through a lot. If anyone has questions, I think you have my email, and you could reach out to me, and I can do what I can to help you.
Perfect. Also, for those of you tuning in today, if you have other topics that you would like Todd to speak about, please feel free to reach out to us, as we'd love to put together another webinar with Todd.
Okay.
To watch this webinar again, please visit the website beconet.com/flourish. You can also find the calendar of upcoming programs as well. We look forward to seeing you all next time. Hope everybody has a great day. Bye.
Okay. Thank you.